Well, good morning, everybody. Thanks for coming out here in what we think is cold when we're in Washington, D.C., but it really isn't cold in a lot of other places in the country. And we're here in front of the Supreme Court building to make the point that in the history of this country, we have never seen an Attorney General make such a decision. I mean, we are at war. And it's been defined as war, although it's not been declared as war. We sent troops to Afghanistan in the late fall of 2001. Troops into Iraq in late March of 2003. And we have picked up hundreds of our enemy across the world. And there's been a framework that's been laid out to try them down at Guantanamo Bay. There's been a facility that's been constructed for that purpose. And this Congress has twice acted to lay the foundation out to try these enemy combatants down at Guantanamo Bay. And first, we had a decision made by the administration. The Congress followed up on that and made a decision to pass the Detainee Treatment Act. That was an Article 3, Section 2 stripping of appeals to the Supreme Court and left the exclusive appeal at the D.C. Circuit. And yet the Supreme Court reached in and heard the case, and now we had the first opening where you might have people that had never set foot in the United States, had never seen the United States, and never aspired to be a citizen or protected by constitutional rights of the United States, granted some path to the Constitution through the detainee treatment, or through the Hamden decision, which was on the Detainee Treatment Act. Then Congress acted again and passed the Military Commissions Act to accommodate the decision of the Supreme Court, and it opened up another case, the Boumediene case. And yet, once you sort all of that out, a legal foundation exists to try Gitmo detainees down at Guantanamo Bay. It's the best place to have them. It's the best place to house them. It's the safest place. But more importantly, it is the place that keeps activist federal judges from making activist decisions that could end up turning people loose on the streets of America. And so that's the framework. And when the Attorney General, Eric Holder, had made the decision to bring Khalid Sheikh Mohammed and the other 4 detainees to New York City, 6 blocks away from Ground Zero. It's the first time a decision like that had ever been made in the history of this country. It sets a new predicate and new premise. And we're here to say we don't want to allow these enemy combatants, the Al-Qaeda enemy Islamic radical jihadists, a toehold or a beachhead on U.S. soil in a U.S. legal system. That's the message that's coming out of here this morning with my esteemed colleagues behind me, and that's the framework. And we're going to start this out with Andrew McCarthy. He's a co-chair, a Center for Law and Counterterrorism at the Foundation for Defense of Democracy. He was the lead 1995 terrorism prosecution against Sheikh Omar Abdel Rahman and 11 others, and the defendants were convicted in the 1993 World Trade Center bombing. Andy McCarthy knows this Constitution. Andy McCarthy knows this law. Andy McCarthy has lived this, and I introduce to you now Andy McCarthy.
Thank you.